Cool. Well, good evening, everybody. Thank you for joining this presentation about what things can go wrong with SEIS, or even EIS. Some of you may have come to the presentation that we did a couple of weeks ago, which was the introduction to EIS. This one is looking at the problem, so what can go wrong. If you would like to look at the session from a couple of weeks ago, it's on our website. If you go to the Insights page, you can click to find that, and we'll reference it as we go through this presentation. So if you're sort of looking for a basic intro, then have a look there. Before we start, a bit about us. So we are a law firm based in London. We work exclusively with startups. So obviously our competitors do bits of startup stuff and bits of other stuff. This is everything that we do. All of our clients are startups. Startups is a little bit of a loose term. So for us, our clients tend to be anywhere from pre-incorporation founders all the way through actually to exit. But the sweet spot for us is that sort of early stage stuff up to about Series A, Series B. To be honest, almost all of our clients tend to exit in that sort of time frame. So typical exit values sort of 50 to 150 million. That tends to be where most of our clients get out. In terms of us, I'll start with me. So I'm Mike. I'm the founder of the firm. I used to work on what I flippantly call the dark side of law, so do sort of $500 million plus M&A for listed companies. Back in 2011, I quit and set up this firm, and the origin of that was essentially that I started doing bits of startup work at my last firm. Really enjoyed it. Really enjoyed working with startups, and realized this is what I wanted to do. As the sort of core bit of my career. Other than doing legal stuff and advising startups on all the legal things, I'm also entrepreneur in residence at a bunch of the London universities, so provide sort of a combination of sort of mentoring and training to startups with them. I do bits of investment in startups, not in our clients, I should say, because it causes too many conflicts of interest. And I also wrote the best book ever written, if I say so myself, which is called Built on Rock, and it's basically sort of an overview of all the stuff you need to think about as you set up a startup from a legal perspective. Sitting next to me is Ellie. Do you want to tell us a bit about yourself, Ellie?
Yeah, so I'm Ellie. I'm an associate here at Buckworths. I joined the firm over 3 years ago now as a paralegal, and sort of worked my way up. I became a trainee after sort of 6 to 12 months or so, and I've been with us since then. I do a lot on angel investment rounds as well as VC investment rounds, and I'm looking, quite in depth with FEIS and EIS during my day-to-day.
So Ellie, we joke internally, is the queen of EIS. She knows basically everything that there is to know, font of knowledge. So in terms of what we're going to cover, as we've said, this is really looking at the things that can go wrong. So the way we're going to break this up, Ellie's going to talk about the sort of the legal background to these topics, and then I'm going to talk about some of the sort of problems that we currently see. So I guess starting at the first topic then, Ellie, do you want to tell us a bit about growth and development requirements and the risk to capital condition?
Yeah, so as Mike mentioned, we did a previous introductory webinar to the EIS, and in that we briefly mentioned these points. At the time, we said that we were going to go into them in more depth in this webinar because they're really important to get right. HMRC says that these are the 2 most important conditions that you consider and make sure that you comply with to understand if you might be EIS eligible before you look at any other criteria. So the first part is the growth and development requirement. And what that is that HMRC says that you must use all of the investment monies that you receive under EIS for the company's organic growth and development over the long term. Now, long term isn't actually defined by HMRC, which is a little bit tricky, but HMRC do impose a minimum 3-year holding rule on EIS shares. So an EIS investor must hold their shares for 3 years if they want to gain that EIS benefit. So that gives you a sort of indication as to what might be the sort of minimum long term that they need. So when you are either applying for advance assurance, which we mentioned in our previous webinar, or also if you're submitting an EIS 1 compliance statement on behalf of investors, you will be asked to submit accompanying documentation, and that will include business plan and also financial forecasts. It's really important to make sure that those are appropriate, number one, for the funds that you are seeking, so the amount, and that you indicate how you will grow and develop as a company over the long term. So there are a couple of key indicators that we would recommend that you include that HMRC has on their manual and that we've got here on the slides. The first would be increasing revenue over time. The second would be expanding customer base, and the third would be increasing employee numbers. Now, this isn't an exhaustive list, as I say, it's just a recommendation of key indicators. It sort of depends on the company and what you're doing, so it could be different, but we would definitely recommend including these details if you can. As I say, it's really important to get this right, and it's stuff that we do every day. So if you're not quite sure how to sort of set out that information, we can certainly help you do that. The second part is the risk to capital condition, and it's worth noting that you need to get both the growth and development requirement right and the risk to capital condition. It's not one or the other. So the risk to capital condition basically says that at the time of the investment, so at the time the EIS investor gives their money to the company, the investment must pose a significant risk of a loss of capital of an amount that's greater than the potential net return. So there's a couple of points on this. The first is significant risk. And again, there's not actually a definition of significant risk given by HMRC. They're going to look at a couple of different things if they want to sort of figure out if that has been a significantly risky investment. The first would be looking at the company itself, the investor, and also, as I say, the risk of losing the money and the net investment return that they foresaw. So that would be looking at potential dividends or capital growth. And it is worth noting, though, that if, let's say, in 5-10 years' time, the company that you've either invested in or your company has done really, really well, that doesn't necessarily mean that they have not met this condition. It just means, that's great and they've grown and developed, but it's just at the time the investment is made, it needs to be significantly risky.
So in terms of the stuff that can go wrong, we'll take the growth and development requirement first. So the first thing that we see a little bit too frequently is people putting what we call working capital buffers in cash flow forecasts. So when you apply for an advance assurance, what you're generally going to send to HMRC is a load of financial forecasts. And really there's two bits to it. There's cash flow forecasts, so how you're going to spend the investment money in the next sort of 2, 3, 4, 5 years, and also profit and loss forecasts, so how you're going to generate profit going forwards. What founders, by the way, very sensibly do is they put in their cash flow forecast a reservation of an amount of money which they're saving for a rainy day. So you might say we're going to have 50,000 quid that's just going to sit in the bank account in case something goes wrong and we need to have a little bit of extra cash to play with. Of course, that's good business practice. It makes a load of sense, and I totally get why people do it. The problem is EIS money must be spent wholly for growth, and keeping money in your bank account against a rainy day doesn't qualify for EIS. And if HMRC see that cash buffer, they won't give you advance assurance and they won't give you EIS on that amount of money you've kept back. So your cash flow forecast needs to show you're going to spend all of the investment money. So that's the first one. The second one is around sort of growth metrics and how you think the business is going to grow. So as Ellie said, what we are saying to HMRC when we submit an advance assurance and then demonstrating to them when we claim the tax relief is that the use of the investment money will lead to organic growth of employee revenue and customer numbers. So you have to show HMRC the type of numbers that we're talking about. So what you might think to yourself is, today perhaps I've got 1 employee, and in 2 years' time, I'm going to spend my investment money, I'm going to have 10 employees. Same principle with revenue, same principle with customers, it's going to go up. What's super important is that those numbers you give to HMRC are achievable and they're realistic. If you were to say to HMRC, at the moment we've got no revenue, but in 2 years' time we're going to have £100 million worth of revenue, if and when you don't meet that threshold, and let's just be flippant and say, in 2 years' time, you don't have £100 million worth of revenue, you've got £5,000 worth of revenue, there is a very good chance HMRC will say you haven't met the growth requirement because they gave you the advance assurance based on your estimations. You have missed them by 1,000,000 miles. You haven't met the requirement. Now, it isn't to say if you give estimates and miss them, then you've got a problem. That's not the case, but it's a question of quantum. And if you're telling them you're going to have 100 million of revenue, and you're getting 5,000 of revenue, that's going to be an issue. So try to be realistic, don't overstate the metrics. And then the final one, EIS requires, as Ellie said, that investment money is used for growth and not just for maintenance. So what you should never be doing is raising money and claiming it or trying to claim EIS when all you're trying to do is keep the business afloat. So the classic example of this would be during COVID. Restaurants and hospitality businesses, they were closed for the lockdowns. They incurred loads of liabilities, paying rents and rates and all this kind of stuff. When the market came back and they were able to trade normally, lots of restaurants went and raised money from investors. Nothing wrong with that, that's absolutely fine. But some of them tried to claim EIS on those investments. And really what that investment was paying, it was paying historic liabilities and paying to get those businesses open and start trading again. That isn't growth, it's maintenance. And some people who tried to claim tax relief had it voided or didn't get it because it was maintenance, not growth. So really think about this and make sure that you are raising money for growth and you're demonstrating it in your documentation. So next topic then, Ellie. Oh no, this is me still, isn't it? So risk to capital condition. This is the other condition that Ellie was talking about. So there's a couple of potential problems here. The first one is very similar actually to what we've just been talking about. So putting in your P&L forecast overly optimistic profits and break-even amounts and timeframes. So again, the point here is that investors are making high-risk investments. If you are telling HMRC that the business will break even in a year and is going to be making £1 million worth of profit in 2 years, they are going to say this is not risky enough. You don't miss the risk to capital condition, therefore it's not EIS eligible. So be pragmatic and frankly make sure that you're not showing break even within the 3-year EIS period as a rule of thumb. The second one is a sort of a slightly more general point. You must make sure that if you're going to claim EIS, you are raising money for a business that is inherently risky. So if your business is trading, it's profitable, it's doing really well, and you want to raise some investment, perhaps to accelerate your marketing activities, or perhaps to build a bit of tech that will complement the business, that's not EIS-able. You've got a trading business that's profitable, there's minimal risk here, so you're not going to be trying to qualify for EIS. EIS is there for highly risky businesses, so massively loss-making businesses, early-stage businesses that are yet to grow and scale. So sort of bear that in mind. And then the final one, exit. For most startups, exit is the point where investors are able to get their investment back. That's where they make their return. HMRC don't allow you or don't allow investors to retain all of their tax relief if there's an exit within 3 years of the date that they invest. So what you shouldn't be doing in the forecast is showing exit definitely within 3 years of the date of an investment, but frankly, I would say within 3 to 5 years. So again, don't be too optimistic. By all means, tell investors that you have a plan for an exit. Of course, that's important, but just make sure the timeline is long enough that it isn't too attractive and isn't going to persuade HMRC that there's very little risk here. So on to the next point then. Ellie, tell us about share requirements.
Yeah, so there are a bunch of different requirements that HMRC imposes on shares in order for them to be EIS eligible. On the first point on the slide here, we talk about a couple of points that I'm going to touch on briefly because we did actually talk about them in our first webinar. So if you're not sure what I'm talking about, go back and have a listen there. But the first one is the interaction between FEIS and EIS shares. And what that is essentially if you as a company want to raise an investment round and perhaps you have FEIS allowance, which is the baby scheme of EIS, and you want to allow investors to invest under the FEIS scheme, and you also want investors to be able to invest in the EIS scheme, you need to make sure that you take FEIS investment first and that you issue the FEIS shares first, at least 1 business day before you take EIS investment and issue EIS shares. And it's really, really important to get this right. If you do it on the same day or if you do EIS first, that voids the SEIS. And the second point is around a 30% rule. So it's saying that an investor who wants to claim EIS cannot hold more than 30% of the issued share capital and the voting share capital themselves or with their associates. But as I say, we talk about that quite in detail in the first one, so have a look there. But there are a couple of other points which are really, really important. So when shares are going to be EIS eligible, they need to be newly issued ordinary shares at the time of issue and throughout that 3-year holding period. So if we break this down, the first part is that they need to be newly issued. So they need to be new shares allotted to that investor for that investment. So they can't be shares that are already in existence, so they can't have been transferred, those shares, for example, from another investor, whether they did or did not claim EIS. If they've been transferred, they won't be EIS eligible. So as I say, they need to be new shares. And the second part is that they need to be ordinary shares. And what that means is that they can't hold a preferential right. So they can't carry preferential rights to either dividends, in most cases, a company's assets on a winding up, and they also cannot be redeemable.
So in terms of the sort of things that go wrong here, there's really a couple of things that tend to come up relatively frequently. The first one relates to option schemes. So if you think about the following circumstance, you've raised some EIS investment, you now want to incentivize your team members to stay with the business. So what do? You grant them options over shares, so the right to acquire shares in the future. If you've got employees, you're probably going to be using a scheme called EMI, which stands for Enterprise Management Incentive Scheme. And what that is it's basically a tax advantage scheme. So the employees can get shares when they exercise the option in a really tax efficient way compared to if they were just issued them outright. Now, when you put an EMI scheme in place, what you do is you go to HMRC and you agree a valuation for the shares you're granting the options over. And if you're granting an option over ordinary shares, say, and you've just raised an investment round, then the starting point for calculating the value of those ordinary shares will be the price paid by investors in that round. Now, in practice, we can get some discounts on that, but this is the sort of the principle. You're looking at the reference price that investors paid in the last round. Now, shares, ordinary shares, have got three rights attached to them. They have a voting right, a dividend right, which is right to profit, and a capital right, which is essentially a right to the proceeds of sale. In order to bring the value of shares down, what you can do is remove some of those rights. So what you might be tempted to do is create a new class of, say, B ordinary share that doesn't have voting rights and doesn't have dividend rights. So the only rights it has is the proceeds of sale. So it gets share of the proceeds of sale. If you do that, then the value of those shares will be significantly less than the ordinary shares. And so you've made, if you like, the position more tax efficient for the employees. The problem, though, is that by doing that, what you've done is you've meant that the ordinary shares have a preference over those ordinary B shares, so the shares you're granting to your option holders. And that has the potential to void the EIS tax relief. So I think the message here, to be honest, is if you're doing stuff with options, talk to lawyers about it. And if you're using a lawyer who hasn't been involved in your EIS, make sure that they're aware of it and make sure that they understand the way the EIS impacts on or the way that options impact on EIS. As I say, this is something that people screw up, unfortunately, quite frequently, and it isn't, frankly, very easy to solve the problem once you've done it. The second one is, again, a slightly techie point, but it relates to deferred shares. So if you think about founders tend to have all of their shares issued to them up front. But when you do investment rounds, investors will say, if the founders were to leave the business, we want the ability to take some or all of their shares back off them. So what you often put into the articles is a provision that says, you know, the founders are deemed to earn their shares over, I don't know, 3 years from the date of the investment. And if they leave, the shares they haven't earned, the unvested shares, are taken off them. So there's a lot of mechanisms, there's a couple of mechanisms to take unvested shares off founders, but one of them, and the most common way of doing it, is to convert the unvested shares into what are called deferred shares. And deferred shares, in layman's terms, are shares that don't have a voting right, don't have a dividend right, and they have a right to a preferential £1 payment in the event of a liquidation or a sale. Now, when you create deferred shares, what you do is you create a clause in your articles, which is called liquidation preference. And what it basically does is it allocates the proceeds of a sale or a liquidation to the share classes in a particular order. It's massively important that the deferred shares get their £1 as a priority in front of any ordinary shares or any EIS shares issued to investors. If you do it the other way, you're going to void the EIS for the investors. Now, interestingly, HMRC's manual, their guidance on this, says that actually it doesn't matter if you put the deferred shares below the ordinary shares in terms of the distribution of proceeds of sale. I personally would say take that guidance with an extremely large pinch of salt. And the reason is that there's a tax tribunal case from 4 or 5 years ago where the tax tribunal voided all of the EIS that have been granted to investors in a company because there was a single £1 entitlement for deferred shares that ranked below the ordinary shares. And so tax tribunal have said it doesn't work. HMRC's guidance isn't binding on them. So in this case, I would say ignore their guidance, just make sure deferred shares are done in the right order. So it's basically in the liquidation waterfall, deferred shares first, ordinary shares second, so that the deferred shares are getting their payment before the ords. So next topic then is advanced subscription agreements, one of your favourite topics, Ali. So do you want to tell us about this?
It is. So as a bit of background to this, I'm going to just do a bit of an extension to the previous share requirement point, which is actually that you also need to be really, really careful about any significant delay between taking investment from an investor and issuing their shares. Because the longer that you wait, the more likely that HMRC will say that it's a loan, and a loan is not an EIS eligible investment. So what we're seeing becoming quite increasingly common these days with our clients and founders is wanting to enter into what's called an advanced subscription agreement. And what that is basically what it says on the tin. So where an investor subscribes their investment in advance for shares to be issued in the future. And we're seeing a lot more of this because what it means is that a company can take investment quicker without necessarily having to ascertain the valuation, because you can sort of change that depending on the terms that you include in the ASA. Now, the way that the ASA works, just as a bit of background, is that once the investment has been given to the company, there are then a bunch of different conversion events that can occur in order for the shares to be issued. So the most common of these would be on the next investment round, which may be sort of at a minimum threshold. So you might say that on the next investment round, raising say 500K or $1 million or something like that, then the shares will be issued, the ASA will convert. Could also be on an exit, so a share sale or an asset sale, or it could be on a long stop date, which is essentially a date which is set in the ASA, which is a point in time from the date either that the ASA was entered into or the investment was received. It's really important to note that, and I'll revisit that in a moment. That if none of the other conversion events have happened, then the shares will be issued and the ASA will convert. Now, as a rule of sort of thumb, the more complex that your ASA is and the longer that period between the long stop date, the less likely that HMRC are going to see it as an EIS eligible ASA. So they've given a bunch of requirements that they expect to see in an EIS eligible ASA. And so what these are, the first one is that it must not permit repayment of the investment at all. So as I say, a loan is not an EIS eligible investment, so it cannot be repaid. It must be subscribed up front and with no ability to repay it. As a bit of an extension to that, it cannot carry any interest. So again, it cannot look like a loan, it's not accruing any interest, it's just the money that's subscribed up front, that is the amount. It cannot be varied, cancelled or assigned. So at no point in the future can you decide that you want to change the terms of the ASA, and so you then decide to vary it. That would void the EIS eligibility of that ASA. And then as I say, really, really importantly, this long stop date must be no more than 6 months from the date that either the ASA is entered into or the date that you receive the ASA investment, whichever is earlier.
And so just for reference, there is a precedent platform out there who issue what they call seed fasts. Seed fasts are essentially ASAs. It's basically the same thing. So in terms of what can go wrong, there's a couple of things. And what I would actually say here is that when people come to us with problems under EIS, ASAs is one of the biggest sort of causes of problems. And so I wouldn't say don't use them, but I would say if you're going to use them, you should just acknowledge that there are some risks inherent in it. It is always going to be safer to do a price round, issue the shares and claim the tax relief. So ASA is a little bit riskier, and here are the sort of the key things that can go wrong. The first thing to be aware of is that HMRC's view of an ASA is that it isn't there to give any economic benefit to investors or the company. So their view is that you use an ASA simply to align investors who are investing at different times and over a period of time so that their shares are issued on one day. So it's a way of making the paperwork easier and nothing more. Now, in practice in the market, a lot of people use ASAs in order to delay the valuation. So almost like a convertible, right? They want to delay the valuation for the company, and or they want to be able to play with some of the terms. So perhaps give people a preferential right by giving them a discount on the next round price. It's super important to realise HMRC don't think that works. And so whilst the market does it and people get away with it, you do need to be careful about what you're doing. So you need to make sure that you're not granting economic benefits to ASA investors compared to other investors. So things like the discount at the next round price should be a smallish discount. So market standard is 10 to 25%. What you shouldn't be doing is giving a 75% discount. If you present that to HMRC, there's a very good chance they're going to have a problem with it. So, you know, try not to be too clever. As Ellie said earlier, try not to make these things complicated. The second one, and the one that comes up all the time at the moment, is around the long stop date. So, as Ellie said, the long stop date, in order for an ASA to comply with EIS, the shares must be issued no later than the earlier of the date of the advance subscription agreement and the date the company received the money. Noting, of course, that for lots of companies, bizarrely, investors pay the money before they actually sign the ASA. So, you know, it's the earlier of receipt of money and date of the ASA. The problem comes when companies sign different ASAs with different investors. So you may have 20 investors, every single one of them signs a different ASA. If you think about it, if they all sign and pay their money on different dates, what you find is that investor number one, he converts on the 1st of July. Investor number two converts a week later. The share capital that is used to calculate the price per share for investor number two is based on the share capital post-conversion of investor number one. Now, that doesn't matter if everybody is converting on identical terms, but it does matter if you've got different discounts and there's weird stuff going on as well, which is actually very often the case. And if you get it wrong, you can actually find that the valuation that each of the investors is investing at ends up different, and potentially it goes down over time, which is a bad thing for loads and loads of reasons. So if you're issuing multiple ASAs to multiple investors, you either need to set a date and say all of the ASAs will convert on the 1st of August, knowing that that date is no more than 6 months after the first investor in the round paid their money or signed their ASA, or you put a sort of formula in that makes sure that the same effect happens on a variable date. But it's super important that it's done. This is, by the way, something that we're seeing almost every week at the moment, with people sort of doing ASAs themselves, not spotting the point, coming to us to convert it. And as we're about to talk about, once you've signed ASAs, you can't change them. So you are unable to solve the problem at this point. So that neatly brings us on to the final point. ASAs, a condition of an advanced subscription agreement being EIS qualifying, is that it cannot, under any circumstance, be amended. So there are lots of reasons why you've signed your ASA and you might want to change it. The classic one actually is you signed your ASA with a default conversion price on the long stop date at a valuation, I don't know, 3 million. We're in a difficult economic environment. There's a bit of a credit crunch going on. You might have raised a small amount of investment in the interim, not enough perhaps to have converted the ASA, but you've raised some nonetheless. You've done a down round. You've done an investment at a 1.5 million valuation. You won't be surprised to realize that your ASA investors are going to be super upset if you've raised money at 1.5 and a month later they are converting at 3 million. And in that circumstance, maybe you think you did a good deal, you're super happy about it, but maybe you actually want to reduce the valuation. You can't. If you start playing around with that agreement, you're varying it and you void the EIS. So ASAs are not variable, and don't forget it. I think it's probably the message there. So state aid, which is my least favorite topic in the entire world because it's super complicated, but Ellie is going to tell us about it and make it super simple, aren't you?
Yeah, it's definitely a term that I think scares people and people aren't quite sure what it means, but I'm going to try and set it out as simply as possible. Basically, the term simply refers to assistance, usually in the form of money, given from a public body or a publicly funded body to a company which has the potential to distort competition and affect trade between member states of the EU. Now, there are two sort of types of state aid that we're going to look at now. The first is de minimis state aid, which is essentially of a value low enough to not distort trade or competition. And the second is notifiable state aid, and that aid that's sort of, a little bit higher value and therefore needs to be approved by the European Commission. Now, all venture capital schemes are state aids. So EIS is a venture capital scheme, as is FEIS, the baby scheme. FEIS is actually de minimis, as in it's low enough to not, to fill competition, as I mentioned, and EIS is a notifiable state aid. Now, as we mentioned in our previous webinar, a company had a certain allowance for claiming EIS per year and in their lifetime. So per year, they can raise 5 million under EIS and 12 million in their lifetime. Now, what you might not realize is that any notifiable state aid that you raise will actually decrease excuse me, this allowance that you have to raise EIS. So by way of example, if you raise state aid, for example, as an Innovate UK grant, let's say you raised £250,000, that year your EIS allowance will be decreased to 4.75 million. It's also worth noting that it's actually applicable for the whole 3 years prior to the EIS raise that you make.
And Ellie has basically hit the nail on the head there about the problem and the thing that catches people out. It is basically grant funding. So Innovate UK that Ellie was talking about is the government's grant funding body. They've pumped literally tens of billions into it in the last couple of years. So if you are doing something innovative, worth having a look, by the way, and seeing if there is a funding project that you could apply for. It is free cash. Sometimes you need matched investment funding to get it, but definitely worth having a look if you're doing something innovative. But as Ellie says, Innovate UK funding is state aid. So if you've raised if you've got Innovate UK funding within the last 3 years, you need to take that off the 5 billion entitlement. If you get your maths wrong, you've, let's say, done £3 million worth of Innovate UK funding in the last 3 years, you're trying to raise a £3 million round, you're going to blow through that 5 million annual cap, so $1 million of it isn't going to qualify. Super upset investors if you haven't spotted it. So do the maths, make sure you haven't forgotten state aid.
Cool, so the commencement of trade and the EIS time limit. So basic age condition, which we talked about a little bit in our previous webinar, basically is a requirement from HMRC that within the first 7 years from the date of the first commercial sale of a company, they have to have raised their EIS investment and issued their EIS shares. So that's the period they have to raise their EIS investment. Now, in our next webinar on the 20th of July, we're going to look at this in more detail because there is a way that you can extend this basic age condition through sort of either being a knowledge-intensive company, as you can see on the slide, that would extend it to 10 years. There's requirements there for your employees and sort of research and development you're carrying out. There are other ones that are called Condition A and Condition B, and as I say, we'll look at them in more detail, but essentially, what they do is extend the limit to 10 years. What you do need to be careful of is, what you do need to be careful of is knowing what the date of your first commercial sale is, because you need to take into account your company's first commercial sale, any subsidiaries you have, and also maybe any company that you've acquired previously.
So in terms of what goes wrong, I think there's a couple of things here. The first one is more an FYI, to be honest. So what a lot of founders do is when they're doing their first beta launch, they're getting their platform, their product, whatever it might be out there, they actually let people pay for it and they see if they can generate a bit of revenue from it. Nothing wrong with that, but if you then effectively go away and spend 1, 2, 3 years building out your product before you properly launch it, those little first trades you did start your commencement of trade date. And that's where your EIS period runs from. So if you've gone and done a couple of small transactions with clients in 2020, you launch in 2023, you've wasted 3 years of your 7-year EIS period. And it's not something you necessarily want to do. So my advice would be, if you think you're going to do a bit of beta testing, and then there is going to be a significant period of time before you properly launch, make sure you don't take any money from customers in the beta testing phase. Because you are going to lose a bunch of time there. The second area that does cause problems is around buying businesses. So the specific point in terms of time limits is if you buy another business and that business has got a trading date that is earlier than your trading date, your commencement of trade, then as soon as you acquire that business, your commencement of trade date jumps back to the earlier date of the business that you've acquired. So before buying a business, make sure you check what their commencement of trade date is and that you're not going to screw yourself over in terms of your own EIS time limit as a result. And then the final point is really just here because it's a simple point, but unfortunately founders seem to have a misunderstanding of the way that this works. Pivoting your business, so changing the nature of the business to do something slightly different, does not reset your commencement of trade date. So if you started trading on the 1st of January 2020, you decide you're going to pivot to do something slightly different this year through the same business, your commencement of trade date is still the 1st of January 2020. You don't reset it. I only raise it up. I probably in the last month or so had 5 or 6 clients who thought that the pivot changed the date. It doesn't, and obviously don't make that mistake. So businesses in distress, something that causes us, particularly at the moment, a bit of distress. But tell us about this, Ellie.
Sure. So just taking this back to sort of the general financial health requirement, what it is a requirement that HMRC imposes where a company must be considered solvent. So they can't be insolvent in HMRC's eyes, and there are a couple of tests for this. The first is that they must be able to pay their debts if they fall due. So if they're, if you did invoice, they must be able to pay that on that day. And the second is that the value of their asset must be higher than the value of their liabilities. So, as we mentioned before, there are ways to sort of extend your period to claim EIS. And if you do that, so if you go into the period between 7 and 10 years, HMRC also imposes an additional requirement in order for your company to be considered solvent. And that is basically that you mustn't have accumulated losses of more than 50% of your issued share capital.
So in terms of what goes wrong here, I think there's a couple of points. The first one relates to the interaction between EIS and the criminal offence of trading whilst insolvent. So in reality, lots of businesses that are doing an investment round have either run out of cash or through the process of raising the round, they run out of cash. There are 2 tests for insolvency. The first one is you can't pay your debts as they fall due. So in other words, if you've got an invoice that is due today and you can't afford to pay it, you are insolvent. And then the second one is that your liabilities are greater than your assets, so looking at your balance sheet. Technically, if you are insolvent, you're not eligible for EIS. But the reality is that it happens to lots of companies that this is the case. As long as they close the round, they go on to continue trading, and they stay trading for another 12 months, this is never going to be an issue, and the EIS is perfectly safe. So that's the EIS side of it. Trading whilst insolvent basically means that as a business, you are continuing to incur liabilities in circumstances where the directors know or should know that the company is not going to be able to pay them. And so if you have run out of cash, you can't pay your debts as they fall due, and there's no basis on which you're going to be able to pay those monies, then as the law says, you should stop trading immediately. And if you don't, you commit a pretty serious criminal offence that can make the directors personally liable for the debts of the company. So if you're in that position, you should be talking to lawyers about it. And if you're in the process of raising a round, what the lawyers will say is, don't worry about this too much, because you're able to continue trading in the reasonable belief that you will be able to close the round, and that will solve your solvency problems. And what we would say to you is hold regular board meetings, acknowledging that you are cash flow insolvent, but emphasizing the fact you're raising this round, and that will solve the problem. The problem from an EIS perspective is those board minutes acknowledge you're insolvent. And if HMRC were ever to look at them or to see them, they would potentially void the EIS. So you have this really difficult problem that as directors to make sure you avoid personal liability, you want to document the insolvency and talk about the fact you're raising around and can get out of it. From an EIS perspective, you do not want to be documenting it. I think the point here is basically talk to lawyers about it and figure out the safest approach, but it is just something to be aware of. Of course, the practical point, and I know it's easier said than done, is make sure you raise a round before you run out of cash. Easier said than done, yes, but that's probably that is the way to avoid this particular issue. The second sort of point here, Ellie's already touched on. So this is the point that once you hit that 7-year period after the company started to trade, you will potentially look to qualify as a knowledge-intensive company, or fall within one of the conditions that enables you to extend your EIS period up to 10 years. The problem is, from 7 years onwards, if your aggregate accumulated losses are more than 50% of your paid up share capital, so basically 50% of the amount of investment that you've raised, then you are ineligible for EIS. And by the way, this rule changed this year, so it's a relatively new point. So I would say all startups need to be acutely aware of this. The reality, to be honest, is there's a credit crunch at the moment. A lot of VCs particularly are beginning to refuse to invest in startups who can't demonstrate that they are prioritizing profitability and are either close to break even or have got a very clear plan as to how they're going to get there fast. And so, you know, a lot of companies who are getting towards the 7-year period can't raise through VCs and therefore are forced to try to raise through angels. So it's just super important, I would say, to prioritize profitability and make sure you're not getting to 7 years and needing to continue to raise money, or at the very least, making sure that you've got smaller accumulated losses that are less than 50% of your share capital. So final topic then, before we go on to questions, claiming tax relief and all of the tricky timelines on that then.
Yeah, so claiming tax relief, use it or lose it. Pretty daunting, but these are time limits that you really, really need to stick to. So all the money that you raise under EIS must be used wholly for the purposes of the qualifying business activity within 2 years of the date of the issue of shares. You must file the EIS non-compliance statement on behalf of an investor within 2 years of the end of the tax year that they make the investment. And whilst it's not necessarily on you, it's worth reminding the investor that they have 5 years from the 31st of January from the year following the date that they invest to claim their EIS relief. If they don't do that, and they then want to claim EIS in the future, they will have invalidated it purely because you can't hold shares which are non-FEIS or EIS shares if you then want to claim EIS. So all the shares you hold in the company must be FEIS or EIS. And further, it would invalidate any further tax claim that they expect to make.
So in terms of what goes wrong, it's sort of the points that Ellie's raised, but there are sort of the 2 different bits to this. The first one is you must claim the income tax relief if you're an investor. And this goes wrong in 2 places. A, the company forgets to put in the EIS 1, that is the first step to claiming the tax relief. And to remember, that's effectively 2 years it has to do that. So if you are the company, try to make sure that the EIS 1 is done as soon as the transaction completes so that it doesn't get forgotten. And if you are the investor, remember to chase the company because it's easy for this stuff to be forgotten. If you haven't, as an investor, claimed that tax relief, you're not going to be eligible for the capital gains tax on sale or for the loss relief. The weird thing, and I'll be honest, it astonishes me sometimes, the company will have claimed EIS, they will have filed the EIS 1, HMRC will have approved it, it will have sent the investor the EIS 3, and then the investor will have done absolutely nothing. Just because you're able to claim the tax relief doesn't mean you've got it. You must claim the tax relief through your accounts. And as Ellie said, you've got 5 years to do that. So claiming that income tax relief is absolutely vital and it mustn't be forgotten. The second one is tough because the timeline is much shorter. So if the company goes bust or your shares are disposed of at a loss or a lower valuation, then you might be entitled to claim loss relief. But the crucial point here is you as the investor, this is not the company's obligation, you as the investor must notify HMRC that you are entitled to loss relief and start the process of claiming it. And you have 9 months to do that. And again, if you don't do that, you lose the loss relief. So super important to keep on top of this kind of stuff. Before we take questions, a little bit about the next session. So on the 20th of July, we're going to talk about the age requirements and exceptions. So what this is basically is it's looking at how companies who've got to the end of their 7-year EIS period are able to extend that period to 10 years by falling under one of the conditions that HMRC set out. If you are a founder and you've got a startup that is getting towards the end of the 7 years, this is definitely relevant to you. If you are an investor or you're an early stage founder, this is interesting stuff and it's worth being aware of because, you know, 7 years passes pretty fast and you may find yourself up against it. So that's it from us. I think, Ivan, do we have any questions that we can run through?
Yes, absolutely. Hi, everyone. My name is Ivan, and I'll be helping Mike and Ellie with the questions. Thanks so much for the insightful presentation, guys. I'm pretty sure that everyone found it really helpful. We've got lots of questions, but of course we do have limited time, so I'm just going to read a few questions. And the first question that I picked up is from Rashida, and she's asking, what happens to EIS qualification if the company pivots its business to a non-qualifying activity?
That's a good question. I'll grab that one. So the point here is that in order to be eligible for EIS, the company has to be carrying on a qualifying trade. And so if you did a pivot to a trade that was entirely non-qualifying, then future investors would be unable to invest under EIS, and actually your existing investors would have their EIS voided. So the classic example might be, you are currently operating a tech platform that matches people who want to rent a car with car rental companies. That qualifies its software provision, so it's nicely within inside the rules. You decide that tech's not your thing, you're going to pivot the business and you're going to buy a load of cars and start renting cars instead. Rental of assets is entirely non-qualifying. So if you did that, you'd void tax relief for existing investors who are within their 3-year holding period, and you wouldn't be able to raise further EIS. So that's the sort of the easy example. The slightly trickier example is where you pivot into a type of business that is part qualifying and part non-qualifying. And so what you have to think about here is you have to think about what proportion of your revenue and cost the non-qualifying aspect of the business is. So a good example might be you're a fintech startup. At the moment, everything you do is qualifying, but you start to take deposits from customers. Deposit taking is non-qualifying for EIS purposes. And so you have to figure out, is the revenue and cost of the deposit taking part of the business less than 20% of the whole business? If so, you still qualify, it's not a problem. But if it's more than 20%, then it may be an issue. If it's more than 20%, then future investors won't be able to claim EIS. If it's more than 20%, though, it depends on the extent of it. It's possible existing investors would be allowed to retain their EIS. You would want to ask HMRC, by the way. It's possible they wouldn't. It becomes a sort of a quantum point.
Thank you so much, Mike. The next question that I picked up, it's quite interesting. It's from Anna, and Anna is asking, my company has already raised ES, but I've realized that we have issued a class of B share that is less preferential than ordinary shares investors hold. Can I just get rid of the B shares to avoid any ES issues?
Well, this is definitely one for you, right?
Yeah, that's a great question. So the short answer is technically no, and the reason being is that HMRC's rules say that shares, if they've had any preferential right through at any time, that would void the EIS. Now, in practice, we would have a sort of a look at what the issue was, see if it was a mistake, or how we could rectify that. If, for example, that you've drafted something in the Articles of Association, for example, a liquidation preference that we've touched on a bit, and you've given your EIS shares a preferential right over those the ordinary, what we would do is seek to, number one, amend your articles to get rid of it, and number two, write to HMRC to explain the situation, show them the new articles, explain that the EIS shareholders had no benefit, and ask them to waive the voiding of the EIS. It is worth noting that obviously that's just one scenario, and I'm sure it can be far more complex. So definitely speak to a lawyer if you do think that you have given a preferential right. And I'd
second that. The EIS rules are actually super complicated, and I think mistakes happen. Inadvertently people do things that have the effect of essentially avoiding the EIS. HMRC can be quite cooperative on this kind of stuff, but if you want to get out of a problem like that, you need to be sending them a pretty legal letter, setting out detailed legal arguments as to why this is a minor breach and why it would be unconscionable for them to void the tax relief. What I wouldn't suggest is you try and do it yourself, because if you don't make the right arguments, the tax inspector will just dismiss it, and it's very difficult to have a second go at them. Like, you either get it first time or you don't really get what you want. So yeah, if you think there is a mistake or something's gone wrong, absolutely get a lawyer to deal with HMRC for you.
Perfect. Thank you so much, guys. We've got more questions. The next question that I'm going to pick up is from Tim. He's asking, can we reset the commencement of trade date by reincorporating?
Now, that's interesting. It sort of ties into something we've mentioned already, but from a different sort of perspective. Generally, the answer would be no, and it's because of that commencement of trade date. If you carried on the business that was the same as the previous company, but you just reincorporated, the likelihood is that HMRC would backdate your commencement of trade date. Could be that commencement of trade date because it's the same business, so you can't get around it that way. Also, to be honest, there's sort of another issue which would probably arise with that is that if you did reincorporate and take the trade from the previous company, HMRC imposes some pretty strict requirements on intellectual property. And what it says is that you must meet this, what's called a relevant intangible asset test. And it says that you must have created, so it's actually all of your IP. And so if you do take sort of the business you've previously been running and the IP that you've previously created and reincorporate, then that company won't have actually made that IP. So it probably wouldn't be EIS qualifying in that respect either.
Perfect. Thank you so much, Ellie, for that. The next question is from Zara, and she is asking, if my company buys another business, will that have any impact on EIS?
Yeah, so potentially, it's definitely something you want to be thinking about. So I guess the first point is the point we talked about earlier. So if you buy a business that has an earlier commencement of trade date, then your commencement of trade date is backdated, if you like, to that business you're acquiring and in its commencement of trade date. So you may lose some EIS period. So that's point one. The second point would be if the business that you're acquiring, is non-qualifying, that may impact on the qualifying nature of your business as a whole. It's not necessarily terminal that. You can sometimes write to HMRC and get a clearance for it. But it's certainly something to, something to be aware of.
Perfect. Thank you so much, Mike. And we have a question from anonymous attendee. And the question is, can we give different pitch decks to investors and HMRC?
Unfortunately, no, they have to be the same documents. Mainly, I mean, the HMRC wants to, see what you've given to the investors in order for them to invest in your company, sort of the indicators that you provided to them for growth and development, and so they need to be the same. So you need to, you can't change the details and send it to one because you think it's perhaps slightly more preferential, for HMR to see that it's more risky, but you do want to tell the investors that you've got all these prospects, they should be the same.
Perfect. Thank you so much, Ellie. Guys, we have lots of questions, but I'm going to take the final 3 questions for the night. As you see, Mike's and Ellie's contact details are on the screen, so you can always drop them an email and ask them questions directly, and we can always organize a Zoom call or a standard call, and you can find out more. So the next question is from Katya, and she's saying, I took investment before my company had opened its bank account, and so the investors transferred the funds to my personal bank account, and I used those monies to buy company expenses. Is that okay?
Now that's a pretty complex situation, actually, but unfortunately, no. To be EIS eligible, the investment would need to have been transferred to the company's bank account. That's just a rule. Does sound like that's some issue that you've got there, so I would definitely recommend contacting a lawyer to see sort of what you can do about that, because it's not as simple as sort of returning the money and then that investor transferring it to the company. There are definitely rules that restrict your ability to do that. As I say, they're really complex, actually, so a little bit more than I can go into just on responding to the question.
Perfect. Thanks, Ellie. The next question is from Veron. Veron is saying, I've got a large number of treasury shares as a result of a share buyback. Can I issue those out to investors so as to avoid diluting the current cap table?
So treasury shares are basically shares that are held by the company. And the way to think about it is they're sort of held in suspension. And you can sort of issue them to shareholders and grant options through them and that kind of stuff. The answer is you can't use them you can't issue them to EIS investors, because one of the rules of EIS is that the investors must receive newly issued shares. Treasury shares are already in existence, therefore they don't qualify for EIS. There is actually a secondary point which is worth flagging, which is around share buybacks. So if you do a share buyback at a premium, so you buy shares off some shareholders at a significant value, you can find that the amount that you pay for the shares is reduced from EIS of existing and future investors. So as a rule of thumb, if you're an EIS company, don't do buybacks, actually would be my advice. But if you have done one, you just need to get somebody to check whether it's going to have the effect of reducing EIS potentially entirely for any of your existing or future investors. And there's some quite complex rules around that. So yeah, if that's happened, just drop me an email or check that you're not running into an EIS issue there as well.
Perfect. Thank you so much, guys. And the final question from tonight that we are going to take is from Adam. And he's saying, if you have a knowledge-intensive firm, 7 years old, that will fail the balance sheet test due to the director's loan as short-term liabilities, wouldn't it be easier just to set up a new company to raise funds and use part of those funds to acquire the original company? Accountant has already advised not to convert director's loans to equity.
So I'd be interested in knowing why they don't think it's a good idea to convert. I mean, there's lots of reasons why it may not be a good idea, but that would have been, to be frank, probably my immediate go-to would be to say, get rid of the loan, and it may go some way to solving your problem. But that aside, on the direct question, it probably doesn't work to just reincorporate. And the reason is the point Ellie made earlier. So in order for a company to qualify for EIS, you have to demonstrate to HMRC that substantially all of the intellectual property that company uses has been created by the company raising the tax relief. So if you simply put the existing company into a pre-pack, say, buy the assets out and into a new company, well, the new company isn't going to qualify for EIS unless you can demonstrate to HMRC that actually the product you've got is going to be so significantly changed that it's going to look nothing like the product you've got in the current business. And if you've gone 7 years, it may be tricky to get there. I think the other point would be, again, going back to the point Ellie's made around commencement of trade. If you acquire the business of the current company into a new company, well, the commencement of trade date isn't going to change. It's still going to be the commencement of trade date you've got. So you're still going to be outside the 7-year period. Now, again, there are technical ways you may be able to get out of that. And at a really high level, if you didn't acquire the business, so you didn't acquire contracts, team, all that kind of stuff, and maybe you ripped out some specific IP only, and as a result, therefore didn't acquire the business, it's possible you could restart the clock. But it's always going to be fact specific. So again, on that one, by all means, drop us an email and we can look at the specifics with you separately. So yeah.